So one of the most common questions I'm asked as a defence solicitor is, how do I challenge a drink driving breath reading? Let's say you've been charged with drink driving, you've been to the police station, you gave a sample of breath, and it may be that you were surprised by the result, you didn't think you were over the legal limit, or you just want to check if the machine has produced an accurate reading. How exactly do you go about that? And what are you looking for? What evidence might you want to see? So let's talk a little bit more about drink driving breath cases and some of the ways that these machines can produce inaccurate results. And the first piece of evidence to ask for is the printout that's produced by the machine, the breath machine, once you've given a sample of breath. The printout is treated as a certificate of analysis pursuant to section 16 of the Road Traffic Offenders Act. It's quite a significant legal document, and it should at some stage in this case be given to you, a copy should be served on you. And that would usually be at the time you produce the breath reading, so when you're at the police station in the breath test room, or following a not guilty plea in the magistrate's courts, the prosecution may have to provide you with a copy of that printout. The reason it's really important to look at that printout is because there's certain clues or indicators on that printout as to whether the machine that was used in your case has provided an accurate reading. Now, there are only 3 devices that are currently in use in England and Wales. One is the line intoxilyser 6000 UK, one is the Camic Data Master, and one is the Intox ECIR. The Intox ECIR is by far the most common, followed by the line intoxilyser, and then the Camic Data Master. Now, all of those devices work in a very similar way. They work in conjunction with a gas delivery system for calibration checking purposes. So before and after you blow into the breath machine, it will automatically generate a compressed mixture of alcohol vapour, and the alcohol vapour is set at the legal limit of 35. Ask yourself whether the calibration checks are within the required range. Are the calibration checks sufficient? And does that indicate that the machine was working properly at the time? Now, on our website, we have quite a useful feature. On the home page, scroll down, you'll see that you can check your breath test results online. You fill out the printout that you'll have on our website. You'll see a copy of the printout on the website. Fill that out, that sends the results to us automatically, and then we can tell you whether we believe that those results are reliable or not. So think about calibration checks, think about simulation checks, and have you got a copy of the printout? If you haven't got a copy of the printout, that always arouses some suspicion. Why weren't you given a copy of the printout? What don't the prosecution want you to see? But in most of these cases, we are able to obtain that printout and then check all of these issues for you. Now, another way the machine can produce an inaccurate reading is if there's some kind of interfering substance. So it's often referred to as either an interfering substance, an organic contaminant, or mouth alcohol. Now, there are certain safeguards that are built into the second generation evidential devices, the 3 that I named earlier, and they should be able to detect whether there is any substance that is interfering with the result or falsely elevating that reading. And that machine should automatically abort the cycle if it detects that there is something influencing the result. But that, of course, assumes the machine was correctly maintained, that it is serviced as regularly as it should be. The reason they can't use the roadside reading, if there was a roadside breath reading in your case, is because the roadside handheld device is not type approved for evidential use. The big machines at the police station, they are. The roadside device, that can't detect things like mouth alcohol, interfering substances, organic contaminants, and so it may show a very high level, and it may not accurately reflect the amount of alcohol in your system. Of course, at the police station, these machines are designed to, but because they are type approved, within the scope of that type approval order, they have to undergo maintenance. They have to be serviced regularly, and that usually means bringing an engineer into the station. I mentioned that some of these devices work in conjunction with a gas delivery system. They have a compressed alcohol vapour that's fitted to a tank underneath the machine. Well, that has to be replaced, has to be in date. Now, of course, you wouldn't know any of this unless you ask the right questions, and you're entitled to see most of the evidence against you. Now, it's also worth saying there is a presumption in place as well, a statutory presumption, and the statutory presumption allows the court to assume that the machine was working correctly. And the reason that statutory presumption exists, I guess for obvious reasons, is to stop every person charged with drink driving challenging the result and asking the prosecution to prove that it's a reliable reading. But that doesn't mean to say that you can't challenge that presumption. It's not what we call a irrebuttable presumption. You can challenge it, and you can challenge it in a few different ways. Now, you might say, for example, an error on the printout or an issue with the printout means that the presumption is displaced. Prosecution now have to prove that the machine was working properly because the data on the printout appears to be inaccurate. But it could also be, if the printout appears correct, that the alcohol consumption is not consistent with the reading. So if you consumed 2 pints of beer, that wouldn't typically put a person over the legal limit. It might in some cases, but average person, average man or woman wouldn't usually be over the legal limit based on 2 pints of beer. But what if you're twice the legal limit? Well, does that mean because of the statutory presumption, because the printout appears to be correct, that you have to accept the results? Of course not. You're entitled to attend court and to tell the court that based on your consumption, 2 pints at 6 p.m, you couldn't have been over the legal limit. And that in itself is a challenge to the result, and it means that the prosecution should then be providing more evidence in relation to the reliability of that result, its upkeep, the reliability of the machine, its upkeep, maintenance, service, and then you're allowed to look at all this data very carefully, and if you can find fault with it, then of course it's likely you would avoid a conviction. It's also on a practical level, the problem it creates to the prosecution. Now, it's no secret, the prosecution are first to admit they're very busy. Generally, they're overworked, they're underfunded, they're dealing with huge case numbers. And whilst the prosecution may not accept this, they generally prefer people to enter guilty pleas on first court days. As and when appropriate, it brings the case to an end quickly, and I suppose that's one of the reasons why they offer credit for an early guilty plea, because they want people entering guilty pleas on court days. And that's because it does save time and money and saves resources. Now, if you're asking for lots of calibration records, maintenance logs, service logs, user logs, you can even ask for what are known as metrological logs. You can go back and look at the last 300 tests on that particular machine and see if there's any pattern, any malfunction. It's a massive headache for the prosecution. It increases the workload, it increases the overall cost, it slows down the prosecution's case. And this is one reason why a lot of these cases will fail. Not necessarily because you're under the legal limit, or not necessarily because the machine wasn't working properly, but because the prosecution can't present that evidence in time. And if it's too late, if they serve the information so late in the day that we can't realistically then do anything to it or with it prior to a court date, like instructing our own expert to review it, then you can't have a fair trial. The evidence may not then be admissible, and the case would fail for that reason. So, important to look at the printout. Important to look at all the evidence the prosecution have to provide in a drink driving case, and obviously important to seek legal advice as well. Any of our initial advice is always free of charge, so if there are any questions you want to know about your drink driving case, then make sure you get in touch. My name's Conor, always happy to talk about drink driving breath cases.